This is TWiT.
California, while I think the rest of the U.S. is looking at different means of curtailing, controlling, changing, updating, making changes to social media, California has done a thing of its own with AB 2408. Joining us today to talk about California's new bill that was just passed is TechDirt's own Mike Masnick. Welcome back to the show, Mike.
Hey, thanks for having me. I'm glad to be here.
Glad to get you on to talk about this. I think before we get into the nitty-gritty details of what's going on here and I get a chance to ask you some of your thoughts on it, I was hoping you could start by giving us sort of a very bland, very boring understanding of what AB 2408 is set out to do.
Sure. And I should note that the bill is not law yet. It's passed the Assembly. It still has to go through the Senate, but it looks like that's going to happen. But the bill is a response to the idea that social media is somehow addictive, specifically for children. And so it's a response to that, and it has different provisions in there, effectively trying to say that social media companies cannot try to addict children is the shortest version of it. And if it does, and any harm comes to any child because of the addictive nature of any social media platform, it allows parents to sue and, in fact, to file class action lawsuits against the websites for the addictive nature and the harm that was created. And as part of that, it tries to force the companies to set up an auditing program of any feature or part of their service that might possibly have addictive qualities and to try to stop those before they put those into effect. So that's kind of the simplest summary of the bill.
Yeah, a really good summary of it. I read through it this morning and looked at the different changes that took place and sort of what was defined. One of the things that I note right off the bat from what you were just discussing, what you were just talking about, is that the scope seems awfully broad. Am I understanding that correctly? What is it? It almost feels like in the text, they get very sort of hinty at what they're trying to focus on instead of actually just saying it outright. And so I'm curious, with the broadness of this, what does it mean for, as they see it, as they seem to see it, a social media company to employ addictive tactics? Are we talking about a little animation that comes up when you get a like, or what is the actual addictive nature of social media as far as these lawmakers seem to see it?
It seems incredibly broad, and it really does seem, with this bill, really open to interpretation. The language is written in a very broad way, and it's one of these things that it really kind of leaves it up to the courts, because it allows people to file all of these suits. Almost anyone can file a lawsuit and make it a class action lawsuit over these features and claim that there was some sort of addictive nature to something that the platforms did. So I think, my major concern with the bill is how it just becomes open season for lawsuits on all sorts of websites.
Yeah, so let's get into that. I'm curious to hear, well, I read your opinion on the piece, but I would love if you shared that kind of with our listeners, because you go into detail. You have some great passages in here from another piece, and I'm curious kind of when you heard about this going through, I believe TechDirt wrote about it, or when you heard about this kind of making its way through the system, you wrote about it, but now that it is passed in one of the legislative bodies, you've got more thoughts. And so kind of your take on this bill, particularly with the quote unquote save the children nature of things.
Right. And so, there are lots of bills, both at the federal congressional level and in a bunch of state legislatures that are very focused on this idea that, children are at risk. And it's a sort of a very easy political move to do. Save the children, protect the children, think of the children, And the fact is that, childhood is not perfect for everyone. And certainly people go through periods of times where they're depressed or they encounter challenges or in the process of trying to figure out who they are, especially as teenagers, high school age students, they go through phases. And some of those phases, may be dangerous and may certainly be risky. But this bill effectively allows parents to blame and sue social media for each of those things. And I find that to be really risky. Certainly nobody wants their kids to be depressed, or nobody wants their kids to have eating disorders or to go through other, areas where they may consider self-harm. Those are obviously very scary and problematic issues, and they're issues that society should be working on dealing with. But I don't think blaming Facebook for that is a realistic answer or one that will actually help.
Mm-hmm. And one of the things that you talk about in the piece, of course, you just mentioned it there, is sort of a pivot of that responsibility from the part of the parents to the part of social media. So a scenario, I have a child under 18 and they are on social media and they get to a place where they are using social media regularly to the extent that it affects their schoolwork. It starts to affect their relationships with other people. They say that they would like to focus less on social media, but feel like they can't. And maybe we even go as far as going and seeing a neurologist or a neuropsychologist who does an EEG and can see that there's heightened activity in the pleasure centers of the brain when they use the social media, Twitter, or well, I guess a child would not be using Twitter, but Instagram. It's only for us old people who use Twitter. Anyway, so that seems to show this social media addiction that some psychologists and sociologists have talked about. Now I can go to, in this case, Instagram, or go to the courts and say, my child is addicted to social media. They're not going to pass high school and have to, go to summer school. And now you owe me, I can't even remember, what was it, $25,000?
$25,000.
Yeah, $25,000 for this issue. Where is the sort of larger concern that we see from the Cal Matters article that you quoted from Adam Seif, who talked about kind of the concerns about free speech in regard to this situation?
Yeah, I mean, there are a bunch of concerns, and I do think that the bill raises some constitutional issues, specifically around the First Amendment and free speech, because it's effectively, trying to regulate forms of speech on the internet, and therefore there are some real concerns. And I think Adam lays them out, and he's a constitutional lawyer and a law professor, so he understands a lot of the issues. But it's all of these bills, it's a tricky situation when you're looking to regulate the internet, and again, there are all of these bills in all sorts of state houses and in Washington D.C. Where there's this fine line between regulating conduct and regulating speech. And I think a lot of these bills, and the effort to sort of appeal to a kind of popular audience and to say, we're saving the children, ignores that line and definitely gets at regulating speech and limiting speech rather than specifically trying to regulate conduct. And that's tricky when you're dealing with a platform, the internet as a whole, that is mostly made up of speech, right? There are some conduct elements to it, but it is majority is speech. And so you have to be really, really careful and really, really thoughtful how you would approach any kind of regulatory intervention here. And I think this bill ignores that entirely and just goes down this path that is clearly regulating speech. And I think that if this bill actually does pass and becomes law, then it will be challenged and it will almost certainly be thrown out on First Amendment grounds.
Now, one of the things in this piece that I think is, or not in this piece, but rather in the bill, it says content means anything communicated by means of an internet service, publicly or privately, including written material or messages, oral communications, et cetera. They talk about sort of what is not considered applicable here, and they do have a lot and in there, including social media platform. Here it is. The social media platform does not include any of the following: an email service, an SMS and MMS service, a service offering one-to-one communication orally, a business that is an internal resource or tool, even as far as going into posting comments or reviews related to content produced and published by the provider. And I think they even go as far as to say the content that is posted to these different platforms from different users is not included in that. It is just the sort of social media platforms. Can you talk about that a little bit? Because I think that's where people kind of can get hung up, because it does sound like they're trying to separate the two, but I think the bigger concern here is precedence, right?
Yeah, and so that's exactly what that section is trying to do. It is looking to they know that this bill is going to get challenged, and when they go to court, they want to point to that section and say, see, look, we're not regulating anyone's speech. We're only trying to regulate the conduct. The issue is that, so the way that California would argue this is that they will say that it's the features of the service, so things like likes and notifications and whatnot, that are the addictive quality, and it's not the content that is bringing people back. I think that's a really difficult argument to make. Mm-hmm. The reason that people are using Instagram and TikTok and whatever else is not the likes and the notifications. It's the content that they're receiving. Mm-hmm. This bill tries to effectively ignore that and insist that is not the case. And I think that's a really difficult argument to make. And I think that the courts will have a difficult time believing that the state is just narrowly regulating that type of activity rather than attaching it to the underlying content.
Yeah, and in the Cal Matters article, he even makes the argument that algorithms could very well fall within First Amendment rights, because those algorithms are created by human beings that are setting certain editorial rules for those. So fascinating.
Yeah, I mean, that issue is kind of complicated, and it's one that I think is important to think through. This idea that recommendation algorithm, is that protected speech? And there's a really strong argument that it is, because a recommendation is an opinion. It is suggesting what you should be reading, and that is a form of expression. And therefore, there's a very strong argument, and there are a number of different precedents that suggest that recommendation algorithms are protected speech, and any attempt to regulate them would run afoul of the First Amendment.
My last question for you: should this bill make it through the Senate and get signed by the governor of California, what are your sort of crystal ball predictions of how social media companies will respond to this? Are they going to wait for the Supreme Court to shoot it down? Are they going to immediately ban all people under the age of 18 or who claim to be under the age of 18? How do you think this plays out if it is going to pass?
I mean, it's a big question. I mean, there's a number of different paths that they could take, based on how they've responded to different, but in some ways related bills in Florida and Texas. I think what they will do is sue, and they will sue to invalidate the law and say that the law violates the First Amendment, and also is preempted by Section 230. And there's a few other, legal paths that they can take. I'm sure they will discuss the idea of banning people under the age of 18. I think that's kind of the nuclear option. I don't think that they would do that immediately, but I have no direct insight into what any of the platforms would would necessarily do. But the most likely thing is they would go to court, try and stop the law, and then have that process play out, which may take a few years before it's determined. And ultimately, I think pretty clearly the courts, unless something major changes, the courts would find this bill unconstitutional.
Mm-hmm. Well, Mike Masnick, I want to thank you so much for taking some time out of your day to join us here on Tech News Weekly. Of course, folks can head over to techdirt.com to check out your work. Is there anywhere else they should go and watch out for those algorithms that are addicting them?
I do rattle on Twitter quite often. So Twitter at mmasnick. It is if you want to see the pre-processed thoughts before I write stuff out more carefully on TechDirt.
Sounds good. Thank you so much. We appreciate it.
Thank you.